Hello, my name is Dr. Eric Dover, and I'd like to welcome you to the Medical Mafia Show podcast. This is the first show that we've put together, and it will be a short show, but there will be longer shows in the future going into detail regarding issues that are important to healthcare licensees, in particular physicians, and also the public. The public, unfortunately, is quite unaware of what's going on in the medical establishment, quite unaware of how they're being affected adversely, although I seem to feel that they understand that they're not getting a fair shake from organizations such as the Oregon Medical Board. Anyways, the first thing I'd like to do is educate folks in regards to a Supreme Court decision that came out in 2015. It's called the North Carolina Dental Board of Examiners versus the FTC decision, and it is a landmark decision. It's just now really starting to hit the courts in regards to being tested. If you'd like to look into this, and I encourage you to, a bit further, then go to my website, drdovervsomb.weebly.com, and go to the page that's marked North Carolina Dental Board, NCDB, and it'll give you the Supreme Court decision in total. You could read through that. It's really not that hard to understand. The Antitrust Division of the Department of Justice has already endorsed this decision in regards to a case that was occurring down in Florida in the Miami Federal District Court in regards to the Florida State Bar. There is a statement that was sent to the federal court there. The Florida State Bar was told that they have no oversight and therefore they do not have what is called Parker immunity. Otherwise, if you're not following what the North Carolina Dental Board outlines, then you're not going to have immunity. This immunity is called Parker immunity from a case, Supreme Court case called Parker v. Brown. Again, the North Carolina Dental Board decision was in regards to the North Carolina Dental Board, who told the folks that were not dentists, that were whitening teeth, that they had no ability nor right to whiten teeth, and that only dentists could do that, and that if they did continue to do it, that there would be fines and legal action. Well, the FTC, the Federal Trade Commission, got involved, actually at the administrative law level in North Carolina, and the dental whiteners won. The dental board lost. The dental board was not very happy about this. They took the Federal Trade Commission, the FTC, to district court, where they lost. The dental board appealed this at the appeals court level and lost, and then they took it to the Supreme Court, where once again they lost, and this final landmark decision was made. Now again, this involves a dental board, but actually it applies to all state boards. It isn't just dental boards, it's every state board. As I said earlier, the Florida State Bar has already been told that they do not have immunity from lawsuit. In other words, they can be sued in their person. They are not allowed to have Department of Justice legal advice or representation. They would have to go out and get their own lawyers, and they would have to pay out of pocket for their legal representation, like the rest of us actually have to do. And it's my opinion, why should anybody have immunity anyways? I don't see in any instance, in any circumstance, where somebody should be allowed to have immunity, especially when they've done something criminal or unconstitutional. And that includes judges. I don't care who you are, politician, judges, police, regular citizen on the street. Nobody deserves immunity, and certainly the rest of us, your average Joe or Jane out there, does not get immunity. In fact, we usually get the exact opposite. We get the book thrown at us, and we're unable to afford legal representation, and so we plead down, or we acquiesce to whatever they want us to do, and we lose. We always end up losing. So again, the North Carolina Dental Board decision is important for everyone. I know from my own personal experience, and I know from talking to doctors across this country, that they are getting the short end of the stick. They're getting screwed. I hate to put it that way, but that's the way it is. You go into the medical board or any healthcare licensing board, and you are not given the opportunity to have due process or any constitutional rights. If you do not acquiesce to everything that that board says and sign a statement under duress called a stipulated order, then you are going to either immediately lose your license or you're going to go on to a sham hearing. And it truly is a sham. And I don't use that lightly, because when you go there, you are not allowed due process. I've got a letter that states that explicitly from the Oregon Medical Board. Other folks have been told the exact same. If you don't sign that stipulated order, then you're either going to lose your license immediately or you're going to end up being forced into a hearing. At the hearing, you are not allowed any constitutional rights. You're allowed to have a lawyer there, but the lawyer is really treading on thin ice as it is, because if they get too aggressive with the Oregon Medical Board, or any medical board, I can speak explicitly about the Oregon Medical Board because that's the one I'm most familiar with. But if they get too aggressive in regards to their stance in defending a healthcare licensee, then they're going to be a target themselves. Number one is, I know for a fact from speaking to lawyers that if they don't, quote, follow the rules of the Oregon Medical Board, then they won't have access to the investigators or other members of the medical board to speak to them directly. The other thing that they're concerned about is losing their own licenses. The Oregon State Bar is basically in cahoots with the Department of Justice and the healthcare boards or any licensing boards. The Oregon State Bar isn't going to do anything to correct these measures. It's already been treated. Complaints have been made. Complaints in regards to things as serious as the Department of Justice feeding a doctored up proposed order from an administrative law judge that oversaw a psychologist case. They handed them, now you think that immediately if the Oregon Court of Appeals saw something like that, that there would be some type of legal action, but there's not. But a group of us, 13 of us, signed a letter asking for this to be investigated. But unfortunately, the Oregon State Bar doesn't feel it necessary to investigate. And we've appealed it to higher levels, to their executive committee, etc. They still don't care. So in the future, now that we have this North Carolina Dental Board decision, it's a different playing field. And again, I'll say it one more time, it's a different playing field for licensees, and it's a different playing field for the public. The public is getting the short end of the stick in two different ways. Number one is, if they have a good doctor, which it seems to be primarily good doctors that are having either their licenses restricted, or there's a stipulated order put in place, or they're put on probation, or they're revoked, and those patients lose their doctor. Once that kind of black mark or scarlet letter, whatever you want to call it, is placed on that doctor's reputation, and that reputation goes all the way to the Federation of State Medical Boards, where they keep it on a computer, and it goes all the way to National Practitioner Data Bank in Washington, D.C., where any health-related institution can take a look at that, and they have access to a one-sided story that the medical board has sent them. So again, patients are losing good doctors, in particular chronic pain patients, because any doctor that's in any way, shape, or form involved with chronic pain management is getting knocked out of is losing their license, or to the point where if they're like one doctor here in Oregon, his license has been restricted for opiates it was restricted for 5 years. Couldn't find a job for 5 years. No one wanted to hire him. He couldn't contract with insurance companies. He couldn't get malpractice insurance. He can't get a hospital appointment. He couldn't even get into the military, Iraq or Afghanistan. He's an excellent doctor. He's had no adverse outcomes with patients. He's had no malpractice cases. He's had no patient complaints. The only thing that he can figure out is that somehow a pharmacist, most likely, he doesn't feel it was a patient, and it doesn't seem to be a patient, made a complaint. But the complaint's anonymous, and the complainant's anonymous. So he has no idea of what really even happened. He signed a stipulated order. He waited 5 years. That ended in May of 2019. they still haven't removed the restriction. And here it is, February of 2020. It's going to be a year, and they're still not going to have removed that restriction. This poor man has lost everything. He's living in a rusty RV. His wife has already divorced him over this 5-year period and remarried. He has 2 little boys that started off at 5 years of age. They're twins. And now they're both 10, maybe 11 years of age at this point in time. And he still has no job. He's extremely frustrated, as you might imagine. He'll never be able to work in healthcare again. He couldn't even get a job driving a school bus because of these broad terms that the medical board likes to use, or any of these licensing boards like to use, like unprofessional conduct or negligence. I don't know what he was unprofessional or negligent about. Nobody does. Not even Dr. Jane Orient, who came from the American Academy of Physicians and Surgeons out of Arizona to speak with then Executive Director Kathleen Haley, who retired about a year and a half ago. But it's no better with her replacement, Nicole Krishnaswamy. She was Kathleen Haley's protege for 10 years or more, and she's just slid right into that position and is acting and behaving the same way that Kathleen Haley and the rest of the bunch have been behaving. And that includes a very, very, very incompetent Assistant Attorney General by the name of Warren Foote, who is out of control and is legal counsel for 5 different boards. And in each of those, he basically acts as the tyrant and the bully in these situations, along with other individuals on those boards too. So again, getting back, when a patient loses their doctor, they lose their connection. They lose a person that they know. They lose a person that they trust. They lose a person that was helping them make it through their medical situation. The other way that patients lose is that when they are damaged by a physician. Now, I'm not here advocating that all physicians are bad. I think most physicians are pretty good. I think most physicians care about their patients. I think as times change and as we become as we become more focused on the computer systems and the software associated with those, and pushing patients through as quickly as we possibly can, that is breaking down. The patient-doctor bond is breaking down. But the thing is, again, that when a patient is injured in any way, shape, or form, and they complain to the medical board, that individual has some type of connection with the medical board or licensing board, they're basically given a free ride. They're basically allowed to get away with literally up to murder. And I don't mean purposeful murder, but how about, healthcare that is so atrocious that they let somebody out of their office with a blood pressure of 80 over 40 and a pulse of 130, and then that patient ends up 2 or 3 hours later at the emergency room and dies? I mean, there's something grossly wrong with that. And so patients lose because they aren't able to get justice. Again, I'll call it justice in regards to the licensing board taking care of that physician or other healthcare licensee or any licensee that has a board. They're not able to get that taken care of because that individual, that licensee, has connections that frees them from any type of market or traumatic insult to their ability to practice. So here's a good example of what can occur. Again, I gave you the example of the doctor that's down in Eugene and how he just had a restriction on his license for opiates, and how that has destroyed his life because he signed a stipulated order and it went to the National Practitioner Data Bank and the Federation of State Medical Board Data Bank, where they send that out to every medical and licensing board across the nation, so that if a doctor has a license in another state, that's gone. And there's no way for them to remove that stigma, no way whatsoever. Once it's on those computers at the National Practitioner Data Bank, unless it is purposefully removed by the medical boards, it will stay there for eternity. In fact, again, this doctor that's down in Eugene is not even allowed to drive a school bus. He's just looking for work. He wanted to drive a school bus. They wouldn't allow him to drive a school bus because of this restriction on his license and this negligence and unprofessional conduct that is loosely, just loose terms that are used by the medical board. Compare that with Dr. Keith White, who was on the medical board, and about, 5 years ago, 6 years ago, there was some sort of complaint, we don't know the details of it, in regards to patient boundaries and opiate prescribing. Now, Dr. Keith White is out in Monmouth, Independence. He met with the medical board, he was removed from the medical board, but all he received was a corrective order. He had no restrictions. He certainly did not sign a stipulated order. He got a corrective order. Now, a corrective order does go to the National Practitioner Data Bank and the Federation of State Medical Boards, but it's like a warning, basically. So there's no adverse effect on his practice whatsoever. It does go up onto the medical board's, the Oregon Medical Board's verification website, so you can see that he had the corrective order. But again, we don't know the details. The other thing is that all he had to do was go and take some CME for patient boundaries and for opiate prescribing. Now, other folks have had to go to places where they have to be evaluated for their medical knowledge and for their psychological status. A place out in Denver called CPEP, CPEP. And at that institution, which we really don't know the connection between them and medical boards that they deal with. We don't know if there's any kickbacks. We really don't know that much about them whatsoever. But what we do know is that 80% of people have to go on and take further education from CPEP, which means more time away from the physician's practice, more time away from their family, more money out of pocket while they're not making money. It's disastrous. And contrary to what most people think, yeah, there's some doctors that make some pretty nice coin, no doubt about it. You talk about your neurosurgeons, you talk about your plastic surgeons, etc. They're making money. But when you're talking about a typical primary care physician, like a family physician or an internal medicine physician, they're doing okay, don't get me wrong. But they certainly are not in some situation where they have, $1 million in the bank that they can live off of while they go through this. Most of them are like the rest of us, where they're basically moving from paycheck to paycheck, paying for their kids' education, paying for their mortgage, paying for maybe parents that need some help financially, et cetera, et cetera. Again, they're not starving, they're not doing without, but it isn't like they have a bank behind them to be able to afford their way through this situation. So once that doctor is out of practice or is kept from being able to practice, again, patients are not able to see that individual. Where do they go? Especially if they're out in some rural area. Where do they go? And why does the medical board do this to folks? Why does it go to the extreme of making sure that a doctor never gets to practice again? And all I can say is that there's pressures on them also from institutions and organizations like Public Citizen, where they're demanding physician discipline. I understand why they're demanding physicians discipline, but the problem is, and I've tried to contact them a few times and speak with Dr. Sidney Wolf, or I forget the individual that has now taken his place, but Dr. Sidney Wolf is still there. He won't return any phone calls. He doesn't really want to know what's going on. He doesn't want to know that the medical boards are protecting bad doctors, their friends, associates, partners, etc., while they're using other doctors as sacrificial lambs. Now, these doctors typically that the medical board likes to go after, whether that be the Oregon Medical Board or other medical boards, are competitors. In fact, there was a huge case in Oregon in the late 70s that went through 1988 because it started off in the district federal courts and then it went to the U.S. Supreme Court. And it's called Patrick v. Burgett, B-U-R-G-E-T. Again, that is on my website. You can go there, drdover.vsomb.weebly.com, and you can see what went on there, what transpired. The North Carolina Dental Board decision weighs heavily upon that decision. It is a big focal point for that Supreme Court decision. And again, we're talking 1988 when that decision came out, and here it was in 2015 where it has to be reaffirmed. See, that's the problem, is that these things are put into place, but the states and the medical boards and other licensing boards don't follow it. They don't find it to be necessary. In fact, the The Department of Justice in Oregon has said they don't have to. They say that they're in compliance, but if you read the North Carolina Dental Board decision, they're not. Because the North Carolina Dental Board decision says that they have to get this Parker immunity. They have to follow the Mid-Cal rules. And the first rule is that anti-trade position that the state is taking, where they're breaking the Federal Trade Act, it has to be clearly articulated in the laws and rules of the state. Now, the North Carolina Dental Board says specifically that even if they have done that, that is still not enough to give them Parker immunity. Sovereign immunity, or what they usually get, is absolute immunity for anything they do, whether the boards do it purposefully or not, whether the Oregon Medical Board is being malicious on purpose, which they typically are, or whether they've made a mistake, or no matter what the circumstances might be. So the second rule is that they have to have meaningful oversight. That can't be just the government saying, oh yes, you're a board member, you know, we expect you to do this or that. There actually has to be, per the North Carolina Dental Board decision, there has to be specific oversight by a group that has no ties to that licensing board whatsoever. So let's say in the case of the Oregon Medical Board, it can't be a doctor, it can't be anybody associated with medicine, it can't be someone that has a family member that's associated with medicine. And that entity, that governmental entity, has to have the capability to stop any proceedings that the licensing board is going through, again, in this case, the Oregon Medical Board, and they have the ability to overturn 100% any decision that's made by the medical board. Now, the medical board, the Oregon Medical Board in particular, is making all the decisions themselves. They are the investigator, they're the judge, they're the jury, and they're the executioner. Because if you go to a hearing, if that's where you end up at, number one is you're going to lose that hearing. The Oregon Medical Board has never lost a hearing, ever lost a hearing. And they don't plan on losing the hearing because the whole thing is fixed to begin with. Sure, you get to go to this sham hearing, and you get an administrative law judge, and sometimes you actually get a decent one. Sometimes, like myself, I got one that had ex parte contact with Assistant Attorney General Warren Foote after the hearing was over. And I'm not the only person that's complained about that. I found out that a counselor also had the same experience with the same Assistant Attorney General Warren Foote, and also with the same administrative law judge, Rick Barber. Those complaints have been made and put into the Oregon State Bar, but again, they've fallen on deaf ears. Doesn't seem to matter that these things occur. But again, the Oregon Medical Board has never, ever lost a hearing, and I assume that none of the licensing boards, including, in particular, the healthcare boards, have ever lost a hearing, a sham hearing. Because the administrative law judge, at the end of that sham hearing, writes what they call a proposed order, which is what they think the outcome of the hearing should be. The Oregon Medical Board, if the administrative law judge does not rule exactly the way that they're wanting, they'll just overthrow that proposed order. They'll say, well, the administrative law judge doesn't get it. The administrative law judge doesn't understand it. The administrative law judge got it wrong. So if the administrative law judge's proposed order is not consistent with what the medical board or any of these licensing boards is looking for, then they have the capability, at this point in time so far, to overthrow it. So that's why these boards never lose a hearing. That's why the Oregon Medical Board has never lost a hearing. Now people say, well, you can go back and you can appeal this. Yeah, I guess. When you go to the Oregon Court of Appeals, what you get is this. You get a look at process. They're not going to be looking at your case. Nothing in regards to your case and the specifics of your case are ever going to be looked at again after that hearing. Nobody cares. So once the licensing board, and again in this case Oregon Medical Board, makes a decision, that's a done deal. So if you go to the Oregon Court of Appeals, and initially, up until about 5 years ago, no one won an appeal. The Oregon Medical Board always won. But recently, there have been some overturns of the decisions made by the licensing boards. One is in regards to Dr. Bice, who was a psychologist. And there's been a few different physicians. Again, you can go to my website and you can see those decisions and who the individuals were and what those decisions were. But it's of no help to win an appeal at the state level, because what happens is the case just gets reprimanded back down to the licensing board. It's, in this case, in the Oregon Medical Board. It goes back there. So all the Oregon Court of Appeals has done is just basically shown the medical board what they need to do to clean things up so they can go ahead and revoke your license again. And that's the end of it. Your next step is going to the federal courts. Now the federal courts, the federal district court here in Portland, that has not been a good experience. Number one is that, such as in my case, I had Article III Judge Anna Brown. As I found out a couple, 2 or 3 years later, she was very good friends with Executive Director Kathleen Haley and her husband, Stephen Wax. In fact, she gave an award to Stephen Wax. Now, why Anna Brown would not recuse herself or in some way make it clear that she had a conflict of interest in this situation is beyond me. This is why I don't believe that any judges deserve immunity. You should be able to take them to court and sue them just as well as anybody else that harms you. What I recommend is that healthcare licensees, or just licensees in general, take a look at the North Carolina Dental Board Act. Because as I said, it isn't just about the Dental Board of Examiners. It's about every licensing board. I also encourage the public to look at it, because you need to be informed. And what we're going to be talking about on the next podcast is we're going to be talking about chronic pain issues. Try to acquire our patients, chronic pain patients that have been harmed. And I'd like to interview them for the third podcast. Bring them in either here to the studio or do it over Skype. But I'd like to start interviewing people, because I think for this to change, for the public to get its due rights and for the licensees to get their constitutional and due process rights, that we need to bring everybody together. And in particular, the public is so important. So if you have any questions, please feel free to contact me. If you go to my website, you'll be able to get my email address. You'll be able to get my phone number. Please feel free to contact me. I will block anybody that leaves any abusive or threatening messages. I'm looking for people that really want to work together and solve this problem. I'm hoping that politicians are going to start getting involved. At this point, we're going to close the podcast. Again, this is going to be played on cable access. It's going to be put up on YouTube and some other venues, and it'll also be on my website. Hope this has been valuable for people. I hope that I hope that folks are watching in the future. I hope this is a spark that will expose the criminal, incredibly despicable behaviors of these licensing boards. Again, the one I can speak to most specifically is the Oregon Medical Board, but I know that other boards are also involved with this. The Counseling Board, Psychology Board, Nursing Board, Dental Board, all these healthcare boards are deeply involved in destroying their licensees' lives, the families of these licensees, and the patients. Again, patients are pivotal here. Please, please, please contact me if you're a chronic pain patient. We'd like to get you on the show. We want to hear what you have to say. You don't have to just sit back and take this kind of abuse. You can take these licensing boards, these private trade association boards, which is all they are. Again, they have no immunity and are therefore suable in their person. No help from any federal or state agencies to protect them. Take care. Have a good day. Bye-bye.